In this video, we're going to be continuing our inquiry into the effects of rights in rem when you transfer unregistered land to someone else. So this is part 2 now. In the previous section, we looked at the position from before the 1st of January 1926, and now we're going to be looking at the law from the 1st of January 1926, and specifically the land charges registration. Okay, so the 1925 property legislation refers to 6 statutes, which are listed here, which together fundamentally altered property law. And among other things, the 1925 property legislation reorganised the impact of equitable, note not legal, rights in rem on transferees of unregistered land by dramatically reducing the influence of notice. So the property legislation dealt with the position in respect to equitable rights in rem due to the unsatisfactory nature of the doctrine of notice, which we looked at in part 1 of these videos. So the pre-1926 legislation was fairly satisfactory for legal rights in rem still, so it still automatically binds transferees, but it was the equitable rights in rem that were looked at with the 1925 property legislation. And this was achieved by 2 devices, a scheme of land charges registration and the doctrine of statutory overreaching. And in this video, we're looking specifically at the first device, which is the land charges registration. So the system of land charges registration was introduced by the Land Charges Act 1925 and has since been codified in the Land Charges Act 1972. Now, the scheme of land charges registration was designed to replace the pre-1926 position where equitable rights in rem would bind a transferee of land if they were not equity's darling, thus replacing the uncertain notice doctrine. So Section 2 of the Land Charges Act 1972 provides a list of equitable rights in rem which can be registered as a land charge in the Register of Land Charges. So a charge is the generic label for the list of equitable rights in rem. The most important of these rights are an estate contract. So an estate contract is an umbrella term for a few things, for example, contracts to purchase a legal estate and land, options to purchase, and rights of refusal to buy land. It is also the generic label for the equitable rights which are generated by a valid contract for the grant of a legal estate or legal interest in land. Equity looks as done as ought to be done, remember. Other rights include a restricted covenant entered into after the 1st of January 1926 and an equitable easement created or arising after the 1st of January 1926. Crucially, beneficial rights under trust cannot be registered, and this is what we will look at in the overreaching section in part 3 of this 3-part section. So yeah, these are dealt with the doctrine of overreaching. Our aim of the 1925 legislation was to bring stability and certainty to third-party rights in land. The buyer wanted certainty as to anyone else having rights over the land, and the right holder wants to ensure his rights were protected even if the land was sold on. So that was really why this 1925 legislation came in. So what is the effect of registering an equitable right in rem as listed in Section 2 of the Land Charges Act 1972. The registration of an equitable right in rem as a land charge is deemed to constitute actual notice of that right to a transferee of the burdened land. The registration of an equitable right in rem as a land charge ensures that it will bind all future purchasers and transferees of the burdened land. So, put simply, if the equitable right in rem is registered, it binds. What happens if your equitable right in rem is not registered then? The consequence of failing to register a registrable land charge, for example, that is one of the equitable rights in rem listed in the Land Charges Act 1972 Section 2, varies according to the type of land charge and the nature of the transferee of the burdened land. So Unregistered Class A, B, C 1 to 3 and F land charges are void against any purchaser of any interest in land who gives valuable consideration. So, if the equitable right in rem is unregistered and falls within Class A, B, C 1 to 3 and F, it is void against a purchaser. It will not bind a future purchaser of any interest in the land. Section 17 of the Land Charges Act tells you what a purchaser is: a person who, for valuable consideration, takes any interest in the land, equitable or legal. Midland's Bank and Green shows us that consideration need not be adequate. So, a person buying the legal or equitable freehold or leasehold will get the land free from the unregistered land charge so long as they gave valuable consideration. Unregistered Class C4 and D land charges are void against a purchaser of a legal estate in the land who gives money or money's worth. Now, this rule sounds similar to the other one, but it's actually slightly different. So, if your equitable right in rem is a Class C4 or D one, it is void against a purchaser of a legal estate, not just any interest in the land, showing that it is slightly more limited in that respect, who gives money or money's worth. So alternatively, a purchaser of the equitable freehold will be bound by the unregistered land charge under these classes, as it specifically mentions it must be a legal estate. And money's worth means consideration must take money form. Okay? And all the equitable rights in rem flagged up before as being the important ones fall into the second of these two rules. So, an estate contract is a Class C4 land charge, and restrictive covenants and equitable easements arising after the 1st of January 1926 are Class D land charges. So, more often than not, the second rule here will apply. The other thing to note is that all land charges, even if unregistered, will be valid against a non-purchaser. For example, if the land is transferred by gift. This is because both rules require the transferee to be a purchaser in order for the land charge to be void against them. For example, when someone is given land as a gift. So the donee of land will be bound by an unregistered land charge. So a void land charge cannot bind a purchaser or subsequent transferees of the burdened land, even if the purchaser has notice of the charge. So a void because unregistered land charge will fail to bind even a purchaser who actually knew about the charge prior to the purchase. The irrelevance of notice to the rules relating to voidness. So the land charges registration has been fairly successful in reaching its goal in striving for the elimination of notice, as notice is no longer relevant to the list of equitable rights in rem listed in section 2. The Voidness Rule for Midland's Bank and Green. So, Walter and his wife regret giving their son an option to purchase the farm at a cut price. So, they essentially tried to defeat it, and they were successful in this case. Remember, an option to purchase is an estate contract, and an estate contract is one of our Section 2 equitable rights in rem under the Land Charges Act 1972. The option to purchase here was not registered as a land charge, so we now know we were engaging with the voidness rule. And our land charge is also a Class C4 land charge, as it is an estate contract. So this is the rule we are dealing with. Remember, an unregistered Class C4 land charge is void against the purchaser of a legal estate in the land who gives money or money's worth. Now, Evelyn is the person to whom the freehold is transferred. So the question is Evelyn a purchaser of a legal estate in the land who gives money or money's worth? The answer is yes. She takes the legal freehold and gives £500 for it, so she is clearly the purchaser of the legal estate. Therefore, her son's right is going to be void against him. So Geoffrey's option to purchase has been defeated. It doesn't bind Evelyn, and he can't enforce it against her. Geoffrey's option to purchase is a Class C4 land charge. It is therefore void against Evelyn, as I just said, as she purchased a legal estate in the farm for money or money's worth. Evelyn's notice of the option is irrelevant to this conclusion. So this is the intention of the land charger scheme. We no longer need to worry about notice, and it will no longer come into our inquiry. So even though Evelyn knew about it, it doesn't matter and it is not relevant, although it would have been before 1926, as we discussed in part 1. Evelyn's bad faith is also irrelevant to this conclusion. So bad faith too would have been relevant prior to 1926, but here it is not. Land Charges Registration and Notice. For those equitable rights in rem contained in the Land Charges Act 1972 Section 2, the system of land charges registration has unlimited the uncertainties of the traditional notice-based system. If registered as a land charge, the right necessarily binds the transferee and their successors. If unregistered, the right does not bind the ordinary transferee of the land. In other words, a purchaser of the legal estate for market price, or their successors. So, registered, when it's registered, it will bind, and when it's unregistered, it doesn't bind in most ordinary cases. So it is super simple, and it's sort of simplified the whole process and gets rid of this sort of complicated, nasty notice doctrine. There is a contrast between a name-based system of registration and registration of estates. So land charges are registered against the name of the owner of the burdened estate at the time of the creation. So they are not entered against the title of the land. The important thing to note is that land charges are registered against the name of the owner of the burdened estate. So if Geoffrey had registered his option to purchase, as he should have done, had he been properly advised, it would have been registered against the name of his father, Walter. Okay? And a person wishing to purchase unregistered land must therefore search the land charges register against the names of all previous estate owners revealed in the root of title to discover whether any charges are registered. The purchaser of unregistered land will inspect all the title deeds back to the root of title, which I also discussed in part 1 of the video, and in doing so they will be able to discover the name of all the previous owners of the unregistered freehold. A bit laborious, but they will then search those names in the land charges register, and they will try to see if the land charges have been registered against the names of the previous owners of the land. That is how they discover charges that will be binding on them by virtue of their registration. So let's give you an example. In 1998, Johnny, the owner of the freehold in Whiteacre, entered into a restricted covenant with his neighbour Thomas, prohibiting Whiteacre from being used for business purposes. This restricted covenant was not registered as a land charge. Last year, Johnny sold the legal freehold of Whiteacre to Charles for £1 million, its market value. During his inspection of the property, Johnny told Charles about the restrictive covenant he had previously entered into with Thomas. Last month, Charles quit his job as a city lawyer. He now plans to run Whiteacre as a luxury B&B. Advise Charles, you can ignore issues relating to planning permission. So have a little think. Pause this video if you want to, and I will now discuss this example. So the practical relevance is that Charles wants to run Whiteacre as a B&B. Whether he can do this will hinge on a legal question. It will depend on the restrictive covenant preventing Whiteacre to be used for business purposes, whether or not that is binding on him. This is a post-1926 restrictive covenant. As such, it is a registrable land charge. It is one of the equitable rights in rem listed in the Land Charges Act 1972, specifically Section 2, subsection 5, and falls within Class D, so it was registrable. And if it was registered, it would have been registered against Johnny's name, the owner of the estate burdened by the right. However, it was not registered. So we have to look at the Voidness Rule. That's contained in Section 4 of the Land Charges Act 1972, subsection 6, which and subsection 6 tells us that a land charge in Class D shall be void against the purchaser of a legal estate on the land who gives money or money's worth. So this is the relevant rule we are working with here. Johnny sells the legal freehold of Whiteacre to Charles for market value. Is Charles a purchaser of the legal estate for money or money's worth? Well, yes, he gives £1 million for Whiteacre and takes the legal estate. So the law tells us then that the unregistered restricted covenant is void against Charles. Therefore, Charles is able to use Whiteacre for the purposes of running a B&B. There is no restriction on the land for business purposes. Now, how would your analysis differ if, let's say, instead of selling the freehold to Charles, Johnny gave it to him? So all land charges are void against a purchaser but valid against a non-purchaser. So even if unregistered, the restrictive covenant will be valid. Okay. How about if instead of purchasing the legal freehold, Charles purchased an equitable lease? In section 4 subsection 6, a Class D land charge is void against a purchaser of a legal estate. So if Charles takes an equitable lease, he is not the purchaser of the legal estate. Therefore, the voidness rule does not bite, and therefore the restrictive covenant is valid against him. And finally, how would your analysis differ if the restrictive covenant was registered as a land charge at the time of creation? And here it would bind, quite obviously. Okay, so that is the first section, and in the next video we will move on to the second part of the post-1926 law about how rights in rem affect transferees of land, and that is a specific analysis of statutory overreaching. But if you have any questions about the land charges registration, the scheme of land charges registration, please leave me a comment below, and make sure you subscribe to the channel so that you can make sure you don't miss out the next part of the video, which is coming up very soon. Thank you very much.